Never been this tired. Funniest meme I saw was at the end of the day, know this: one of these two is going to be leaving the country. Ralph Wiggum saying, "I'm in danger." Oh, Understand?
No one. This gets more broken.
Okay, much better. Hello, everyone. Can you hear me at home?
Yes, Professor.
Okay,
Yes.
great.
I hear you.
Great. Sorry, we're starting a minute or two late. There were no lights in the classroom, so I had to run down and turn them on. Let's jump right into it. Class 12 today. As I had told you previously, we're starting with the 11th Amendment immunity. And for some reason that I don't know, Chemerinsky has taken this out of your casebook. So you don't have any of this material in your casebook this year. It's been in every edition up until now, and it's not in there this year. So you will have to rely on the PowerPoint slides and also the materials that I have up on the TWEN site. You'll see methodologies on 11th Amendment immunity, and of course it'll be in the student study guide as well. Now it's important to do this because it's tested on the bar exam. So I do want to make sure that you get it. If you remember, we did the same thing with adequate and independent state abstention. He didn't have that in the book either. So let's do a quick review. Let me, here we go. A quick review. So the whole idea, we talked about this at the end of the last class. Essentially what 11th Amendment immunity is sovereign immunity. States cannot, as a general rule, be sued by citizens in federal courts. Cannot be sued by people or corporations or other entities in federal courts. There are three exceptions to this, and we introduced these at the end of the last class. The last two of which you're subject to be tested on, but the third of which is probably what you're going to be tested on more than anything else. So the first is the states may consent and waive their right to immunity. This is usually done through state tort claims acts. And for this exception to apply, the waiver has to be unambiguous and clear. It cannot be implied by silence or acquiescence. It's got to be clear. Second is a plaintiff may sue state officials in their individual capacities as long as the plaintiff is not seeking compensation out of the state treasury. And I think I alluded to this in the last class, the McCullen versus Coakley case, where Ms. McCullen was an anti-abortion protester, and she was challenging the Massachusetts buffer zone law. Massachusetts has buffer zones around abortion clinics where protests cannot occur. And she was claiming that it violated her free speech rights. And so she sued the Attorney General of the state to get a declaratory judgment asking her not to enforce the law. That falls within this second exception. She's sued as the Attorney General. The state was not against the suit was not against the Commonwealth of Massachusetts. And Ms. McCullen was not seeking monetary compensation out of the state treasury. She just wanted to be able to continue her protesting.
Did
And
she
then,
win, Professor?
what's that?
Did she win?
She did win.
Okay.
And we'll talk about that case when we do First Amendment. I don't want to spend time on it now. The third one is the one we're going to spend the most time on. We're going to spend most of the rest of this class on. And unfortunately, it is the most complex of these. And this is that Congress may waive state immunity under the 11th Amendment if it is done under the enforcement powers of Section 5 of the 14th Amendment. So we've talked about Section 5 of the 14th Amendment. This is the enforcement clause that the Supreme Court has given Congress very little authority under over the years. Some, but not very much. So you're going to see here more or less the same thing, okay? So, you know, Congress can pass laws dealing with discrimination generally under Section 5 of the 14th Amendment. We're going to see later on that it applies to things other than what's in the 14th Amendment through this odd doctrine called incorporation, if we're dealing with federal rights. But for now, we're just going to leave it that, you know, that's usually fundamental rights under due process, and equal protection is what we're talking about. So again, this is the one that's going to be tested on the bar exam. So I'm going to explain something, a new concept to you to help you understand it a little bit more. It's just not going to be any form of discrimination that's going to be good enough, okay? The claim through the 14th Amendment must be a serious case of discrimination. And the most serious cases of discrimination include the following number of things, okay? Race, discrimination on the basis of race, on the basis of ethnicity, on the basis of national origin, or on the basis of gender, okay? Now notice I'm not saying on the basis of age. I'm not saying on the basis of disability. I'm saying race, ethnicity, national origin, alienage, and gender. Those are the big ones. Also, the court holds that if a claim is that a fundamental right, a so-called fundamental right, has been breached, and we'll talk about the fundamental rights later on. We'll have one case that involves the right of access to the courts. Then Congress can waive immunity on those types of things as well. I think the easiest way to do this is to jump the gun a little bit and to start to talk about equal protection and fundamental rights just for a few minutes before we get back into the 11th Amendment. So when I bring a case in court claiming I've been discriminated against by a state or federal government or governmental agency, the court is going to decide what level of scrutiny the case is going to proceed under. Is it going to proceed under the highest level of scrutiny, which is called strict scrutiny, where the government has to come up with a really, really compelling reason why it should be allowed to discriminate, okay? And then a little lower level is something called intermediate scrutiny, which is not quite as high, but you know, still the government has to justify its actions. And then the lowest level is called rational basis scrutiny, where the government is going to be presumed to be acting correctly, and the burden of proof is going to be on the plaintiff to show that the government did not have a rational basis to justify its actions. And the purpose of this is, once again, separation of powers. The government doesn't want to become a super legislature and try to overturn policy that should be done by Congress or by the state legislatures. It's supposed to be a court that interprets the law, not that makes law. So if the matter involves discrimination under one of the individual right amendments in the Constitution, the courts will jump right in because it's the Constitution, right? But if it's involved over something like, you know, should we increase or should we decrease the legal limit for drunk driving from 0.08 to 0.01, and basically say if you register at all, you can be found guilty of drunk driving. Well, that's something that should be left to the legislatures because that's a policy decision, and there's nothing in the Constitution that says that the Supreme Court should be doing it. So the government would be subject to the lowest level of scrutiny in such a case, the rational basis level of scrutiny. So let's go through these and get them down. I'm a believer in repetition. You're going to have to memorize each of these, okay? So you might as well, you know, get them now for the first time. We start with strict scrutiny. This is the most rigorous standard of review. It applies to fundamental rights, and we'll talk about what these are later on: privacy, the right to keep your family together, the right to raise your children the way that you want, the right to decide whether you should get medical treatment or not. We'll talk about all of these later on. Believe it or not, under the federal Constitution, the right to an education is not a fundamental right. Fundamental rights come under strict scrutiny. And then under the Equal Protection Clause, it's race, national origin, and alienage. Race, national origin, and alienage. That's where the Supreme Court has said there's been the highest level of discrimination in the history of the United States on the basis of race, national origin, and alienage. And we'll talk about later on how the Equal Protection Clause essentially begins with a classification, treating groups of people differently. And if there's a classification and the government has to justify it under strict scrutiny, it's probably going to lose. So here's the test under strict scrutiny. The government bears the burden of proving a compelling governmental interest that justifies its action. Additionally, the law must be narrowly tailored to achieve the governmental interest, and the government must employ the least restrictive means of achieving its goals, okay? So that's the test. You're going to have to memorize it. But for now, what I want you to remember is race, national origin, alienage, and fundamental rights. If these cases, we're going to see them clicking off in just a few minutes. If they involve race, national origin, alienage, fundamental rights, it's going to be strict scrutiny, and Congress can waive under the 11th Amendment, okay? Now, the second form of heightened scrutiny is called intermediate scrutiny. Of these three, the top two are heightened scrutiny, strict scrutiny, and intermediate scrutiny. And the lowest one is not called heightened scrutiny. That's rational basis scrutiny. Intermediate scrutiny almost always applies to gender, discrimination on the basis of gender. It's been applied in regard to the status of non-marital children, but those cases tend to be few and far between. The ones you're going to see mostly are gender. Because this is called heightened scrutiny, if it's a case involving gender, Congress gets to waive 11th Amendment immunity when it comes to gender. So what do we have so far that Congress can waive with? Race, national origin, alienage, gender, and fundamental rights, okay? And that's going to be it. There's going to be nothing else. No age discrimination. They can't waive in that regard. No discrimination on the basis of disability or handicap. And we'll see these in the cases. Here's the standard here. You notice it's not as high as strict scrutiny. It's not a compelling governmental interest that's needed, it's an important governmental interest. The government bears the burden of proving that the law or policy being challenged furthers an important governmental interest in a manner that is substantially related to the asserted interest. So again, you're going to have to memorize that for the exams, because these will be coming up again and again and again later on down the course. Now here's the lowest level, the rational basis level, and look how low this is. This is anything that's not a fundamental right, and all classifications other than race, national origin, alienage, gender, it falls into rational basis. The person challenging the government has the burden of proof, must show that there is a total lack of relationship between any conceivable governmental objective and the means to employ it. Very, very hard to prove in these cases. The plaintiff almost always loses, okay? All right, let me click you through these cases. And again, you know, you don't have these in your book. I'm sorry about that. But this gives you kind of the history of where we've gone with the 11th Amendment immunity. This first case in 1976 was written by then Associate Rehnquist, Fitzpatrick versus Bitzer. And this one here, Rehnquist says that Congress does have the right to pass the 1964 Civil Rights Act and award monetary damages to private officials, private individuals who sue their state governments. If the case is based on race, religion, sex, national origin, okay? And he says the reason for this is, you look at the 11th Amendment and the purpose of it is to, you know, to limit the right to access in the courts on the basis of discrimination. The 13th, 14th, and 15th Amendments came afterwards. And when these were ratified, the people ratifying in Congress who wrote them must have had the 11th Amendment in mind and must have meant to expand the power to sue in the federal courts when they enacted the 13th, 14th, and 15th Amendments. Therefore, if the action is under the enforcement provision of the 14th, even the 13th, 14th, or 15th Amendments, but almost always Section 5 of the 14th Amendment, then Congress has the right to say that, you know, because Congress has enforcement power, Congress has the right to pass legislation enforcing these post-Civil War amendments, okay? So the first case is Pennsylvania versus Union Gas Company. If you like this case, savor it for a few minutes because it's about to be overruled in the very next case, all right? This looks like the Supreme Court is about to broadly interpret the ability of Congress to waive 11th Amendment immunity. Congress passes an environmental act, CERCLA, Comprehensive Environmental Response Compensation and Liability Act in 1990. And individuals sue their state governments claiming violations under the act. The state governments claim 11th Amendment immunity, and the majority of the Supreme Court says that Congress may override 11th Amendment immunity as to any of its constitutional powers as long as the law in its text expressly authorizes such suits. This was a very deeply divided court in this case. This opinion was written by Justice Brennan. We've mentioned already that he was a very activist judge who believed in a broad powered federal government. For the people who are in the majority, Brennan, Marshall, Blackmun, and White would be off the bench by the time the next decision came down from the Supreme Court and had been replaced with more conservative justices who believed in keeping 11th Amendment immunity, keeping the waivers very narrow under 11th Amendment immunity. So by 1996, we have the Seminole tribe of Florida versus Florida in an extremely narrow reading of this third exception, okay? Overrules union gas. We've already looked at the Commerce Clause, right? It gave the third part of Article 1, Section 8, Clause 3 of Article 1, Section 8, gave Congress the authority to regulate commerce within nations and among the several states and with the Indian tribes. So Congress and only Congress has the right to regulate commerce with foreign nations, among the states, and with the Indian tribes. Well, in modern history, the big dealings between the federal government and the Indian tribes has involved whether the Indian tribes have to pay federal tax on tobacco products that are sold on reservations. But the biggest one is in regard to casinos, because there are many, many casinos that are built on tribal lands or near tribal lands. Congress passed in 1988 this Indian Gaming Regulatory Act. And what it did was it gave a lot of power back to the states. It delegated the power of regulating the casinos back to the states, but first required the states to enter into good faith negotiations with the Indian tribes in regard to the building of a casino. And it has this long, complicated mechanism of where, you know, where it would be settled if they couldn't agree. And it would eventually come back to the Department of the Interior. Problem is that Florida refused to negotiate at all. They said, we're not going to let you build a casino at all. It openly and clearly violated the Congressional Indian Gaming Regulatory Act, okay? So the Seminole tribe sues, claiming that the state of Florida violated the law, and the defense that Florida raises is 11th Amendment immunity. So if union gas is going to apply, the Seminole tribes get to go forward. There's no immunity. Because the text of this Indian Gaming Regulatory Act clearly waived immunity, clearly gave the right to plaintiffs to sue under the statute, and to sue states under the statute. So this time, Justice Rehnquist says that no, we're overruling union gas, and we're saying that it's not just any congressional authority that Congress can waive immunity over. It's the ones coming out of the 13th, 14th, and 15th Amendment through the enforcement mechanisms. In again, almost always Section 5 of the 14th Amendment. So you see the argument, you know, lined up here. This is where, you know, Rehnquist is saying for the first time, only waivable if it's race, national origin, alienage, gender, or a fundamental right. A casino is none of the above. Therefore, Florida is immune, okay? And what's interesting about this is the dissent says, this is nuts. This is nuts because the Constitution gives Congress the right to regulate commerce with Indian tribes. And this is what Congress is doing in this federal law that is passed. And Florida gets to say, you know, screw you. Indian tribes in violation of federal law, and there's nothing that the Indian tribes can do about it. In a strange way, when it comes to a state defendant, the state defendant sort of gets to overrule the law as it applies to it, gets to overrule the federal law. So that's what the dissent says. What the majority says is, no, we already explained it back in Fitzpatrick. Okay? Article 1, Section 8 existed before the 11th Amendment. And so when the 11th Amendment was passed, it had to take into account these congressional powers and still decided that it was going to give 11th Amendment immunity to the states. And it didn't carve out any exceptions for any of the powers that Congress had in Article 1, Section 8. And the only reason why Congress can waive immunity at all under the 13th, 14th, and 15th Amendment is because they came after the 11th Amendment, not before the 11th Amendment. So again, you have these sort of technical arguments, and you take one side or the other based upon whether you want a strong federal government or a weak federal government. The same tension that's been here throughout the entire course. I've sort of already given you the Stevens dissent, and I'll tell you the Souter dissent once again. He says that the 11th Amendment has a very limited application. It is essentially only when someone sues a different state, not his or her own state. He says it's really a diversity of citizenship immunity. It's not a federal question immunity, and this is a federal question immunity. And if you're going to read the 11th Amendment literally, Souter has a pretty good point, because it clearly sounds like it was originally written as a diversity of citizenship type case. Next case, Florida's at it again. So before, it acted in bad faith with the Seminole tribe. This time it is stealing a copyrighted a product that this college savings bank created. So the college savings bank, and you guys have seen these types of products. If you have young kids, you might have even been thinking about these types of products. College savings bank creates and patents this College Shore CD, which was an annuity that you'd put money into, and it was designed to help parents finance college educations later on down the line. I think the one in Massachusetts at least used to be called a U plan. I don't know if that's still around.
Yeah, 529.
Congress then passes a law, and it says, in regard to patent violations, states are no longer immune. They can be sued in courts for patent infringements. And so the state of Florida literally stole this college savings bank's program, the College Shore CD. College Shore CD sues Florida for the patent violation in the federal courts, and Florida moves to dismiss the case again. And what does it cite? The Seminole tribe case. And what's the result? The same as in the Seminole tribe case, for the exact same reason. Congress has the exclusive power to deal with copyrights and patents. It's right there in Article 1, Section 8. But again, the court is limiting waiver of 11th Amendment immunity to Section 5 enforcement actions under the 14th Amendment. And it says this is not one, okay? Our next case is Kimmel versus Florida Board of Regents. From the first page, what do you think this case involves? Discrimination on the basis of what? Age. Thank you, Teddy. Age. Employees. Florida seems to have really latched onto this 11th Amendment immunity thing here. So Florida State University gets sued for age discrimination in regard to the way that it treated certain employees. and it sued under the ADEA, Age Discrimination in Employment Act of 1967. The ADEA specifically waived 11th Amendment immunity. It was applicable against the states. And so Florida, when it gets sued, the state university, when it gets sued, Florida State University, where's that located? Giving you a geography quiz. Tallahassee.
Florida. What?
Well, yeah, of course, Florida. Thank you very much. What's Abraham Lincoln's wife's name? Mrs. Lincoln. It's in Tallahassee, which is on the Panhandle. Where's the University of Florida located? Gainesville.
Miami.
Thank you very much. Gainesville, and they're big intrastate rivals in sports. In any event, Florida State, FSU moves to dismiss the case, claiming 11th Amendment immunity. And what does the Supreme Court say? Here's what the Supreme Court says. It's got to be traditional and historic discrimination that we've protected under heightened scrutiny. It's got to be discrimination on the basis of race, national origin, alienage, gender, or a fundamental right. Age discrimination doesn't fit into those categories. So it doesn't apply to age discrimination. Age discrimination is rational basis scrutiny, not intermediate scrutiny, not strict scrutiny, okay? Board of
Education.
Trustees of the University of Alabama versus Garrett. This one is under the American with Disabilities Act, alleges discrimination on the basis of handicap. And again, the ADA clearly says that 11th Amendment immunity is waived. Court comes out and says, well, and it's an employee who had cancer treatment. She had to miss a lot of work. When she came back, she was demoted, and she claimed she was demoted on the basis of her disability, so it was discrimination. The court says, well, here's the problem, Ms. Garrett. We've already, and we're going to talk about this case later on when we do equal protection. We've already decided the case of Cleburne versus Cleburne Living Center, which involved a town that didn't want a group home for intellectually disabled adults to live in. And so it used the zoning laws to keep them out, sort of changed the zoning laws to keep them out. And the court said that there is, and I don't know what the court's thinking here, the court says that there is no traditional pattern of discrimination against people with intellectual disabilities or handicaps. So therefore, the standard is going to be rational basis, not heightened scrutiny. So once again, an intellectual disability or a physical disability is not race, national origin, alienage, gender, or a fundamental right, okay? So this case, no 11th Amendment immunity, and the case is dismissed. Alabama gets to dismiss the case. Hey, we have a win coming up here for the plaintiffs. First one in a while, okay? Nevada Department of Human Resources versus Hibbs, 2003 case. Congress passed the Family and Medical Leave Act of 1993, giving employees unpaid leave for health conditions of the employee or the employee's immediate family, and waives, right in the statute, waives 11th Amendment immunity against the states, say that the states can be defendants in the case. And Nevada seeks to dismiss based on the grounds of 11th Amendment immunity. And this time, What does the court say? Well, the purpose of this Medical Leave Act was largely to prevent gender discrimination. And what's going on is a case claiming gender discrimination. Does gender discrimination fit within heightened scrutiny? Let's go. Race, national origin, alienage, gender, sometimes called sex, okay? Gender is one of the protected categories under Section 5 of the 14th Amendment. So because it's, high-level discrimination against groups that are traditionally discriminated against, the court says, yes, you are subject to liability if they can prove their substantive case, okay? Remember, the plaintiff still has to prove the substantive case. All the immunity does is get a motion to dismiss early on, okay? You can see Justices Scalia, Kennedy, and Thomas really want to narrow the waiver, the congressional waiver of 11th immunity. And they want really large showings. You have to show a pattern of discrimination in all of the 50 states in this regard, is what they're saying. Tennessee versus Lane. Has anyone here ever been to the Newburyport Superior Court? Obviously in Newburyport. Well, the claim to fame of the Newburyport Superior Court is that it is the oldest courthouse in continuing use in the United States. And when you walk inside, you know that it's really old. The main courtroom is up on the 7th floor. The stairs to get up there are incredibly narrow, so much so that it's hard for one person to come down and one to go up at the same time. And the floorboards creak when you move around the courtroom, and the acoustics in the courtroom are horrible. And it's just a very, very old court. And when I first started practicing, it did not have an elevator to get up onto the 2nd floor. And I just want you to think about that kind of a circumstance as you read Tennessee versus Lane. So here, this guy who's a paraplegic is charged with violating the law, and he's supposed to make a court appearance. And it was impossible for him to get up to the courthouse to get in for the hearing on his own power. The only way for that to happen was literally he would have had to be picked up and carried in. And so he sues, saying that the non-accessibility violates the ADA, and I should receive compensation. And Tennessee, of course, raises 11th Amendment immunity. And the court here says, yeah, Congress can waive 11th Amendment immunity in this case because we're talking about the right of access to the courts. Let's see. Race, national origin, alienage, gender. What did I mention? Fundamental rights. Is access to the courts in the United States a fundamental right? And the answer is yes.
Yes.
Talk about that later on. The answer is yes. And so the majority says this is appropriate under Section 5 of the 14th Amendment because it's a fundamental right. So Congress had the right to waive. The dissent takes, again, a more narrow viewpoint. The dissent says, well, certainly we're not going to dispute that access to the courts is a fundamental right, but there's no fundamental right for a person to make his way into a courtroom without external assistance. And they say this case is about external assistance, not about the actual access to the courts. United States versus Georgia. The facts here are horrible. So think of a prison cell that looks like this. prisoner, Tony Goodman, is a paraplegic. He has to use a wheelchair to get around. He is kept in his cell for 23 hours a day. His cell is too narrow for him to even turn his wheelchair around. He claims he's been denied access to medical treatment for, such as catheters, treatment for bed sores and boils, no access to mental health care, can't have access to any of the programs in the prisons. He said there's no adequate toilet facilities, and he is forced to sit in his own feces for hours, apparently. He claims he's been injured multiple times when he's been moved out of his wheelchair to the shower or toilet. They're not handicap accessible. So he sues for better conditions, and the state of Georgia says, no, we're immune under the 11th Amendment. And the court this time gives a win to the plaintiff, allows him to go forward with his claims. And why? 8th Amendment. I don't know if you guys talk about 8th Amendment in criminal procedure or not. Right to be free from cruel and unusual punishment. If these claims that he is making are true, then he's making out a sufficient claim that his fundamental right to be free from cruel and unusual punishment should apply. And so it comes under another fundamental right. Well, there we have it. Those are the major cases that you're responsible for under the 11th Amendment immunity, okay? Guess what we just did? So first we started with Article 3, judicial power. Then we did Article 1, legislative power. Which of the big three are we about to move on to? Article 2, executive power. We're about to start the federal executive power. Let's talk about some things here. I'm going to add some stuff that's not in your case book. Article 2, sections 2 and 3 set forth the enumerated powers of the executive. And here they are. There's essentially 5 of them. The president is the commander-in-chief of the military, has a right to demand reports from each executive department, has a right to grant pardons for federal offenses, all federal offenses except impeachments. And by the way, no state offenses, just federal offenses. Has the power to make treaties as long as he gets the advice and consent of the Senate, and that has to be a 2/3 vote on advice and consent. And then finally, and this is one of the most important powers, is the right to appoint ambassadors, public ministers, and consuls, judges of the Supreme Court, and most of the officers of the United States government, most of the employees in the United States government. Article 2, Section 3 has the so-called Take Care Clause. My reading of the Take Care Clause is that it once again seeks to reinforce the notion of separation of powers. This notion that Congress makes the law, the president executes or implements the laws, okay, or enforces the laws. But the president doesn't get to make the laws. And the Take Care Clause says that he, and so far it has been a he, someday that'll be a she, shall take care that the laws be faithfully executed, shall take care that the laws be faithfully executed. So the president controls the Justice Department. The Justice Department prosecutes crimes, determines which civil cases it will bring in executing the law. The executive branch oversees all of this vast administrative network that we have now in the United States. Some presidents have claimed that the Take Care Clause is not a restriction on their power, It is actually an expansion on their power. Presidents Jefferson and Franklin Roosevelt cited the Take Care Clause to impound funds appropriated by Congress. This act was deemed unconstitutional. If Congress appropriates money, the president is required to spend it as appropriated, okay? Some presidents have argued that it authorizes the suspension of habeas corpus. Have you guys talked about habeas corpus in your criminal courses at all? An action to the federal courts for habeas corpus is a claim that someone is being improperly detained and should be set free.
Yes.
It's an action that has existed since long before the American Constitution. Habeas corpus is only mentioned once in the Constitution. It's largely assumed that there is a right to habeas corpus, but it is only mentioned once. And that is in Article 1, which deals with congressional power. And there it says that Congress has the right to suspend habeas corpus, but only in times of rebellion or invasion. That's the so-called suspension clause. Can someone tell me a president who suspended the right of habeas corpus? Probably unconstitutionally. Eddie?
That'd be Abraham Lincoln.
Abraham Lincoln. Abraham Lincoln, very good. Suspended habeas corpus, okay? But some presidents believe that under the Take Care Clause, they have the right to suspend habeas corpus, okay? This isn't in your book. I want to talk about this because I personally hate this practice because I think it's unconstitutional. Presidents increasingly are signing documents called signing statements. What a signing statement is at the time the president signs a bill into law, and let's talk about this just for a quick minute. We're going to talk about the requirements for an act of Congress to become law a little bit later on in more detail. But we need two things for a bill to become law in the United States. We need bicameralism and we need presentment. Bicameralism recognizes that there are two branches of Congress, the House and the Senate. So bicameralism requires that the law pass by a majority vote in the House and that the law pass by a majority vote in the Senate. But it still will not become law until it is presented to the executive, to the president. And the president is given a chance to veto the law. Now, generally speaking, if the president does nothing with the law, oh, and I should know this off the top of my head, I think it becomes automatic law within 5 business days after it's presented. I'll have to go back and look at that if it's 5 or 10 in the Constitution. Those are required. But presidents sometimes, and as I am suggesting to you increasingly more often, presidents sometimes, when they sign the bill into law, will at the same time sign a signing statement that their legal counsel has drafted that says, we think these following provisions of the law are unconstitutional, and we're not going to enforce them. And usually those provisions they cite are ones that would restrict their own power as the executive, okay? So, and this is becoming much more frequent. I think it's unconstitutional. I think signing statements are unconstitutional because the law, the Constitution gives the president only 2 choices. What are the president's 2 choices upon presentment? Sign it into law or veto it, right?
Mhm.
Actually, a 3rd choice, or do nothing and allow it to become law. It doesn't say that a president may selectively enforce the law. Indeed, the Take Care Clause would seem to suggest just the opposite. When Congress passes it, the president is supposed to enforce it, whether he agrees with it or not. And if he disagrees with it, what can he do? He can veto it. He can go back, and the veto can be overridden by a 2/3 vote of, again, bicameral, both the House and the Senate in those circumstances. But look at these numbers. They're fairly staggering. Up until Ronald Reagan became president, only 75 signing statements had been issued in United States history. Between the next three presidents, Reagan, the first Bush, and Clinton, they produced 247 signing statements. George W. Bush himself did more than anyone else, 150 signing statements, challenging over 1,100 provisions of federal law. These were, I'm not going to, defend or castigate Bush. Remember that he was the president who was sitting after 9/11. And a lot of laws dealing with terror came down after 9/11. And it was the position of the W administration, George W. Bush, the president had extraordinary powers to deal with terrorism, the war on terrorism, in that he viewed some of these laws as restrictions on his power. President Obama, although critical of all the signing statements of his predecessor, signed 37 himself. And I actually went on the website this morning and looked it up. There's a website, coherentbabble.com, which I found through the American Bar Association, that lists all the signing statements. And as of today, President Trump has signed 59 signing statements himself. Teddy, question. Turn on your microphone so everyone at home can hear you.
Is there a way to challenge signing statements? Is there like a legal authority, or is this basically they can just sign and do whatever they want?
Yeah. Is there a way to challenge signing statements? I would say that given our justiciability considerations that we've had, it would be tough to sign them until there was standing or some other justiciability ground to move forward. So just the existence of it doesn't necessarily, or even a ripeness argument, just the existence of it doesn't necessarily mean that the president is not going to enforce a particular law. I think what you would have to do is wait for something to happen, which the president was supposed to do, but then claims he's not doing because he reserved the right not to do it under the signing statement. And at that point, you would bring the lawsuit, trying to get an injunction to force him to do which he is supposed to do according to the statute. Not just anyone can do that. It's going to have to be someone with standing, with injury in fact, right? Who's going to be actually harmed by it. And then you got to see whether the current constitution of the Supreme Court is going to deem such a matter to be a political question. It's just a dispute between Congress and the president. We're not going to get involved. Remember the Goldwater versus Carter case when President Carter renounced the Taiwan treaty without getting the permission of Congress. So, these largely are done. A lot of people are uncomfortable with them, myself personally, because, I just don't think the Constitution provides for them or allows them. But there's been virtually no litigation about them at all. So they continue. We're going to see the same thing with executive orders. We're going to talk about executive orders later on. All the presidents issue executive orders. Sometimes they involve foreign relations. The Constitution seems to say that when it comes to agreements with other countries, they should be done through the treaty procedure. But yet presidents who don't think that they can get a ratification of a treaty will just do these executive agreements. A perfect example of that is the Pacific Trade Partnership that President Trump abrogated. Another example is the Iran nuclear deal that President Trump has abrogated as well. These are all done by executive order. Okay, and the problem with executive orders is the next president can just come in and say, no, I'm not going to follow that. I'm going to abrogate it, which is what happens. The president has large powers to deal with foreign affairs. We're going to see this, over and over and over again. And there's basically four authorizations for this. The first two are right in the Constitution. The commander-in-chief power is listed right in Article 2. The treaty power is listed right in Article 2, the right to enter into treaties with foreign countries. What we're going to see from these cases is two other potential sources of power for the executive branch. One is if Congress authorizes the president to act in a particular matter. One would argue this is sort of a delegation theory. The Congress delegates some of its power to the president. And then fourth is the concept of inherent executive power. Inherent executive power is power that is just assumed because of the nature of the job. The president is essentially the CEO of the company, so should therefore be able to do things, similar to what people in large corporations who run large corporations should be able to do on a day-to-day basis. Obviously the first two are easy, commander-in-chief and the treaty power, because they're taken right out of the Constitution, and the Constitution is somewhat specific. And the third two are less easy to deal with. So we're going to start with inherent presidential power. And we're going to start with a very, very famous case that I remember from my law school days, the steel seizure case, Youngstown Sheet and Tube Company versus Sawyer. The Supreme Court decided it in 1952. And the question here is whether the president had the power to seize the steel manufacturing plants in the United States for the purpose of fighting the Korean War. In 1952, the Korean War is ongoing. It was winding down. It wouldn't be ongoing for much longer. Of course, to fight a war, there's a lot of domestic production required. Obviously, facilities to build airplanes, tanks, armaments, clothing for troops, food for troops, things like that. If you ever read up on any of the history of how America, the manufacturing businesses all came together very quickly for World War II after Pearl Harbor was bombed. You guys know, for example, you might not know this, that you could not buy a new automobile between 1941 and the end of World War II in 1945, because all the automobile manufacturing plants were converted into building airplanes and jeeps and tanks and armaments and the like.
By women.
What's that?
Women manufactured that stuff.
Rosie the Riveter, and then the men were fighting in Europe and in Asia, and so many women who had previously been, housewives or school teachers and the like, not so much school teachers, but ended up going into the manufacturing facilities. So the steel workers union was negotiating a long series of negotiations and with the manufacturing companies, and they ended up going out on a nationwide strike and virtually brought a halt to production of steel at that time. this freaked out President Truman because, oh my God, how are we going to continue the war effort in Korea if there's nobody in the United States making what we need for the war effort? So he ordered his Secretary of Commerce, who was then a guy named Charles Sawyer, to seize the steel mills and to commit them to the war effort. Now, there was some history that led up to this. Previously, Congress had passed the Taft-Hartley Act, which dealt with labor relations, and it's in debate going up to the enactment of the Taft-Hartley Act, actually considered whether Congress should grant the authority to the president to seize manufacturing facilities to avoid serious shutdowns, but rejected the notion. Instead, what they decided on was that the executive branch could go in and seek an injunction against the unions from going out on strike under those circumstances. So then, the question arises, Youngstown Steel challenges this seizure. You can't take our plant. I'm not sure why they challenged it, because it seems there's no one in the plant working there anyways, but whatever. Says you don't have the executive authority to be able to seize the plants. And hence this question that I raise, what kind of power does the government exercise when it seizes the property of a private citizen or entity in order to devote that property to a government use?
Eminent domain?
Eminent domain. And the Fifth Amendment's takings clause, the very last clause of the Fifth Amendment, which is very short, there it is right there, nor shall private property be taken for public use without just compensation. So the Fifth Amendment is telling us that the government has the authority to seize steel mills. Steel mills are private property, as long as it's for public use. Seems to me there's a public use here. The public use is continuing the war effort and supporting the troops, who need these materials. But that's not the end of the inquiry, because let's go back to separation of powers. The legislature makes the laws, the president implements, enforces, and maintains the laws, the judiciary interprets the laws. Which is it when someone decides whether to seize property? Is it lawmaking? Is it law enforcing? Or is it law interpreting? I think we can all rule out law interpreting, right?
Mhm.
Yes. It's law making.
The courts don't have the authority to obviously seize property. They can rule on whether it complies with the Fifth Amendment and interpret the Fifth Amendment, right? But they can't make law, okay? So yeah, I think, I don't know who said that.
That was Jade.
Jade says it's more like making the law, and that's what the Supreme Court says. Lawmaking is a function of Congress, not the executive branch. Lawmaking involves what Congress does. They investigate, they debate, they consider policy, and then they vote, and they make laws. And the laws will become the law of the land as long as those two things I mentioned to you before happen, bicameralism and presentment. And the bicameralism means that a law has to be affirmatively enacted by both houses of Congress and then sent to the president. And so here, the court is saying that eminent domain is lawmaking. It is not enforcing the laws or implementing the laws. It is Congress who has to decide whether to take property by eminent domain. And what did Congress actually consider in the Taft-Hartley Act? had actually considered, well, what if we have to seize manufacturing facilities? Should we give that power to the president? And what did they say? Nah,
No.
we'll just let the president go in for an injunction instead, okay? So now Truman says, well, I have inherent power in order to do this type of thing. And I have the commander-in-chief power. I'm trying to wage a war after all. Okay, maybe I don't have congressional approval, but I have commander-in-chief power and power inherent to me being a president that's trying to run a country. Trying to run a country means I get to fight wars, and I need these things for the wars. Supreme Court writes this decision. It says that there are 3 ways the president can exercise power in this type of a case. When Congress delegates the power to the president from the Constitution itself, and if the president has the inherent power to do what he's doing. We've already decided the first one, haven't we? When Congress delegates the power to the president through a statute, it hasn't done that, okay? So for Truman, he's down to one of the last 2 from the Constitution itself. Got to derive the power there from the commander-in-chief authority, it seems to me. And we're not talking about the treaty power, so it seems to me the Constitution itself, his only argument left is the commander-in-chief power and a president's inherent power, okay? We've already talked about what's up in this slide. Congress specifically considered delegating this power to the president, but expressly decided not to give it, okay? So Truman here, clearly exercising a lawmaking function, is saying, I am the commander-in-chief of the armed forces. I have to be able to take this property in order to support the troops and to wage the war effort. And the court says, no, you don't. Commander-in-chief power does not extend to domestic production. It does not extend to domestic labor disputes. That is lawmaking power, not military power. Justice Jackson wrote a concurrence. A very famous concurrence in the case. Justice Robert Jackson, originally from Albany, New York, or upstate New York. The president is not the commander-in-chief of the country, its inhabitants. I'm sorry, this is a quote actually, so I'll get it correctly. The president is not the commander-in-chief of the country, its industries, and its inhabitants. So essentially, the commander-in-chief power is nearly not as great when it applies to the domestic situation, essentially. Even if the domestic situation is indirectly tied to what would be normal under the commander-in-chief power waging war. Justice Douglas says an emergency, regardless of its urgency, doesn't create power. That's kind of a rhyming, an emergency, regardless of its urgency, doesn't create power, okay? All right. Let's start to talk about the concept of executive privilege. And so I pose sort of a rhetorical question here to get us thinking about this. And this is going to lead to the United States versus Nixon case, and then to the Cheney versus District Court case that's in your notes that follow the U.S. v. Nixon case. And there's a fair amount of history here leading up to the U.S. v. Nixon case. But so before we get there, I just want to pose the question. Do you think the president should have the right to keep his conversations with his top advisors confidential in the same way that a lawyer-client, doctor-patient, husband-wife, or priest-penitent communication is deemed to be confidential? If that's the
I would say
case,
yes.
we would call it executive privilege, right?
Yes.
You guys are in evidence class right now. Have you done privileges yet in evidence class?
Not yet.
Not yet.
Yep. Okay, so you guys are going to talk about the lawyer-client privilege, the doctor-patient privilege, the husband-wife privilege, and in some states, not all, there's the priest-penitent privilege. And the notion of all of these privileges is that certain relationships require full confidence and full disclosure of circumstances and situations. And that sometimes these circumstances and situations might be embarrassing, or sometimes they could harm the relationship or harm others if they were made public. And so the law recognizes that the lawyer who represents the client really needs the full story so he can give the client the best defense or the best representation that he can. He's required to do that under the laws of ethics. He or she is required to do that under the laws of ethics, give a zealous representation, okay? And if, you know, the prosecution had the right to come in and discover what was said between the lawyer and the client wouldn't be telling the lawyer everything that the lawyer should know, and it would diminish the representation. And the same with the doctor-patient relationship. You know, sometimes there are some embarrassing things that should be revealed. You know, you guys are law students. How much do you drink? How many days a week do you drink? Things like that. That might affect your health, and it's better for the doctor to know them than to not know them, and they might be embarrassing. The husband-wife relationship as well. You know, the family unit is sort of society still considers to be the bond of a society. And so obviously to maintain the husband-wife relationships, they're the rudders of the family. They shouldn't fear that they could be called to testify against each other or to make concessions as to what one said or did or something like that. So then the question is, should this apply to the president as well? And, you know, I think the reasonable answer is yes. I think there has to be some sort of an executive privilege. I mean, I'll give you a couple of examples. Let's say I remember well when the night that President Obama came out and said that they had got Osama bin Laden. And if you remember the details of that, bin Laden was essentially being held in a compound in Pakistan with apparent awareness of the Pakistani authorities. And Pakistan happens to be an ally of ours. And we didn't even tell the Pakistanis that we were about to invade their airspace and launch a military mission into a compound on their sovereign soil, because we were afraid that they would tip off bin Laden and that he would escape again, okay? So, you know, what if some journalist had discovered this information, had breached, you know, confidential sources to discover that America was on the way and wanted to report on it? You know how the cable news networks all want to be first? It's more important to be first than it is to be right these days, it seems. What might that have done to that very important mission of the United States? And then there are deliberations that the president has to engage in. Do you think it would have made sense, for example, during the Cuban Missile Crisis, if all the deliberations between JFK and his cabinet regarding a possible nuclear strike or a possible nuclear war with Russia had been made public? Or should those conversations be kept confidential? And so I think, and I do know people who say sunshine is the best disinfectant, and there should be no such thing, you know, as classified information or confidential communications whatsoever. I've heard that argument before, I think it's a fairly ideological argument. I think the more reasonable argument is, yes, there should be some type of a privilege. And the law seems to recognize this. Now, where in the Constitution does it say that the president has the right to confidential communications, executive privilege, with his trusted advisors?
It doesn't.
Nowhere. Where is the only place that this is going to come from?
Congress.
Inherent presidential power.
No.
Okay? And, you know, again, this is the notion that just the position of the president being president inherently gives him certain powers that he should be able to exercise. It's common sense to allow the president to be able to do these kinds of things. Which leads us to Watergate, the backstory. There is the Watergate, which is now a condominium complex, which back then was a hotel complex. I have a son who went to the George Washington University, which is across the street from, it's an urban school, it's across the street from the Watergate complex in the Foggy Bottom section of Washington, D.C. I can tell you that it is probably one of the ugliest buildings I have ever seen. Maybe it was much nicer. It was a relatively new building back then. I didn't find it all that attractive when I was there. The Foggy Bottom area is kind of a nice, quaint area. And, you know, George Washington University sort of melds in with it. And then across the street, you have this sort of monstrosity that's hanging out there, but there it is. So let's go back to 1972. Richard Nixon was the president in his first term from 1968. His first term ended in January 1973 when he was re-inaugurated for a second term. He had beaten Hubert Humphrey, who was LBJ's vice president, to become president in a relatively close vote. In 1972, he was running against George McGovern. George McGovern was the Democratic nominee, in which was predicted not to be a close vote, and the prediction ended up being true. Every single state except for Massachusetts voted for Richard Nixon. The only state that McGovern won was Massachusetts, and he also won the District of Columbia. In fact, back in the day, and you know, these were my middle school and high school years. Back in the day, people from Massachusetts, while Watergate was going on, people from Massachusetts would put bumper stickers on their cars when they traveled that said, "Don't blame me, I'm from Massachusetts." Nixon knew he was going to win. Everyone expected him to win, but he was just that kind of a guy. That kind of a guy who had entrusted people to run his affairs and really probably set the tone with them that they were just going to have to get dirt on the Democrats anyways. Because they didn't want to just win the election, they were going to bury the Democrats and bring some people down as they were doing it. So one evening in 1972, a group of people who were called the Plumbers, who were Richard Nixon's henchmen, broke into the Democratic National Committee headquarters in a hotel room in the Watergate Hotel. And they were apparently lousy crooks because they left the door open slightly ajar, and the light from the office came out. It was after office hours, it was at night. And a security guard walked by and saw light coming out, looked inside and saw people in there, and called the cops, and they were arrested in the act. And as the story unfolded, it was just a little news story. I sort of remember it. You know, I don't know. I don't remember how many people. 5 people were arrested for breaking into the Democratic National Convention headquarters at the Watergate Hotel in Washington, D.C. And that was sort of the story. As the story unfolded, um, you know, journalists got involved, started investigating it, and, you know, sort of started going up the chain of those involved. And the chain kept getting closer and closer to Richard Nixon himself. And as it turns out, you know, it's pretty clear in hindsight now that Nixon did not directly give the order to break into the hotel. He might have done so if he had been asked. We'll never know, because the tapes we're about to talk about, there was an 8-minute gap that went missing, that accidentally got erased. One day, while this investigation is going forward, the Attorney General, Nixon's Attorney General, because of all the outcry from the stories that are running in the media, decides to appoint a special prosecutor, kind of like a then version of Robert Mueller. The special prosecutor is appointed by Elliot Richardson. Elliot Richardson was the Attorney General. He was the former Attorney General of Massachusetts, by the way. And he appointed Archibald Cox, who was a constitutional law professor at Harvard University, of all things. One day, while giving testimony in a Senate investigatory hearing, a guy named Alexander Butterfield was asked, whether, just apparently for no particular reason, was asked whether there were any tapings of the conversations in the Oval Office of the White House. And Alexander Butterfield was the guy who basically set up the taping machines and the taping system. And he said, yes, there were tapings. And then the next thing you know, Archibald Cox was subpoenaing the Watergate tapes, you know, from specific dates, not a big fishing expedition, but from specific dates based on, you know, dates that would have been important from the testimony. And by this point, John Dean, Nixon's, not Nixon's, but the government's Office of Legal Counsel, head of the Office of Legal Counsel, had testified, you know, about conversations that he had had with Richard Nixon. As it turned out, his memory was pristine. He almost recounted the conversations word for word. It was shocking. Some days later, or more than some days, months and months later. So when Nixon said, "We're not going to give you the tapes. We'll give you our version of what the tapes say. They're protected by the executive privilege." Cox said, "That isn't enough. I'll take the tapes, please." And the so-called Saturday Night Massacre occurred. And I was a kid, but I remember this well. What happened was Nixon told the Attorney General, Elliot Richardson, to fire Archibald Cox. And rather than do so, Elliot Richardson resigned. The Deputy Attorney General was a guy named William Ruckelshaus. He was second in command. He was then ordered to fire Archibald Cox, and rather than fire Archibald Cox, he resigned. The third in command is the Solicitor General. The Solicitor General is the person who the principal appellate lawyer for the United States. He argues all the cases before the Supreme Court in which the United States is involved. That was a guy named Robert Bork, B-O-R-K. Robert Bork did not resign. He did fire Archibald Cox. And it would later become one of the primary reasons why, when he was appointed by Ronald Reagan to be a Supreme Court justice, the Senate voted not to confirm the nomination. And he never became a Supreme Court justice, and he was asked in detail about that. Cox was fired. A new prosecutor, Leon Jaworski, was appointed. Leon Jaworski went to court. Nixon claimed executive privilege. The case ended up in front of the United States Supreme Court. And I'm going to end the class a little bit early today. We will pick this up on Tuesday. We'll start with United States versus Nixon and go from there. We're pretty much back to following the book again, okay? So I keep doing that. Once we get to the economic rights, just so you know, like the contract clause in the Fifth Amendment, after the Fifth Amendment, you will see on the syllabus, we jump to First Amendment, which is about 600 pages later in your book. And then after Fifth Amendment, we're going to come back and we're going to do the Equal Protection Clause and the fundamental rights, okay? That's sort of where we're headed at. You guys have a great day. We will see you Tuesday. Stay safe, please.
Good, thank you.
Thank you.
Yes, sir. Professor, this is Jade.
Hi, Jade.
You never got back to me. I was going to do a Zoom thing with you.
Okay. Did you send me? You sent me an email on that, Jade?
I did.
Respond?
I did last week.
Okay, I must have missed it. Send me another one. We had office hours yesterday.
Yeah, those times don't work for me. That's why I was.
That's okay. That's okay. Just send me another one today to remind me. Okay.
Okay, will do.
Okay. Thank you.
Have a
Sorry.
good one.
Can I just say the final, no midterm, the final is as on the date that's on the syllabus, November something, right? Because there's 2 dates. So do we know yet? No?
Yeah. You know what, Karen? I don't have enough information to tell you exactly what's up.
That's fine. All right, I didn't know.
The memo that went out says that we're going to have a major exam on the 24th of November, the
Okay.
Tuesday before Thanksgiving. So we are going to have that. And I need to get some more information to determine the rest of what's going to happen.
Okay, thank you.
Okay, bye-bye.
Bye. Have a good day.
Yep.